Hello, everyone. My name is Bob Thomas. I am the president of SACC DC, and it is my honor today to welcome all of you to this webinar, Doing Business in the United States. I want to thank Michael and the team at Foley and Lardner for hosting this event. Not only this event, this is a series of events, which is a great example of the effort that the Chamber is making to continually enhance our programming. So I'm very excited to turn it over. I'm very excited to learn. I hope everybody benefits from this. And with that, I'll turn it over.
All right. Thank you, Bob. I'm Mike Lockerbie, the National Co-Chair of Foley's Distribution and Franchise Practice Group. And we're very proud to have our partnership with the Swedish American Chambers of Commerce. We are a member, but also we're next door neighbors. The House of Sweden, the Swedish Embassy, is right next door. And as Bob said, this is the first in a series of webinars. Next month, we'll be addressing the supply chain, and then we have upcoming presentations on intellectual property law, international trade, and government investigations, among others. I hope you'll join us for those, and those of you who've been with us before also know that this fall we'll have our annual law product distribution and franchise seminar in Chicago, which you'll have the option of attending either via webinar, as you are today, or live and in person. We're very fortunate to have joining us today Mike Going, who was, at the time of the events we'll be talking about, the General Counsel of Volvo Construction Equipment North America. And so he has the unique perspective of an in-house counsel and a business person as to how to deal with the type of litigation we're talking about. So Mike, if you want to say a few more words about your background and then get started with the substance.
Sure, thank you, Mike, and good day to everybody. Thanks for attending, and I'm happy to be able to participate today. As Mike said, back in 1999, I joined Volvo Construction Equipment North America. I was their general counsel, and senior management made it very clear that the top priority was going to be the subject matter of today's discussion. I was with Volvo for about 7 years, and then after that I went to C&H Global, at which time I was the North America General Counsel for that company, also a construction equipment manufacturer, but also an agricultural equipment manufacturer, and then became the General Counsel for C&H Global in 2007 to 2014. I've been in the heavy equipment industry since joining Volvo, so about 25 years, and I've known and worked with Mike and his colleagues for almost 25 years. So happy to be here.
The issues that Volvo faced that Mike Going and I will be talking about are in some cases unique, but many are actually very common for companies that sell their goods and services through independent distributors and dealers. They're not necessarily unique to the equipment industry, certainly not to Swedish companies. And these issues arise whenever there's a desire to streamline distribution, often following a merger, acquisition, or JV, and also when there's a desire, as most companies have these days, to improve the focus on their brand. I think it would help, before we talk about the litigation and the lessons learned, to hear about the business situation that Mike Going was faced with when he accepted the position of North American General Counsel 25 years ago.
So I look at this slide, the first thing that comes to my mind was in 1999, 2000, it must have seemed like all the world was coming to an end. We had Volvo selling its prized jewel, I think, Volvo cars, to Ford Motor Company. We had Volvo Construction Equipment making acquisitions of Samsung excavators and Champion motor graders. We also, for those of you my age, we had Y2K, and we all thought the world was going to end at midnight of 1999. And the product lines, the Samsung excavators and the Champion motor graders, were going to be Volvoized. I'm sure there's problems with that term, but meaning rebranding and some re-engineering of the product. And so we had the main task was made quite clear to me that priority one needed to be the consolidation of the 3 distribution networks, the Volvo dealers, the Samsung dealers, and the Champion motor grader dealers, into one, hopefully more robust distribution network that would be carrying all of the product lines for Volvo in North America. I thought I might just take a moment to talk about some of the important, more business-oriented rather than pure legally oriented things that I learned, some things that I, in retrospect, feel I did well, and with Mike's help and his colleagues' help. The first thing is to focus on planning. Before you start taking action, there's a lot to be said for planning. And when I mean planning, first thing would be to put together the right team. And there's the internal team. It might be somebody who, in our case, was the head of dealer development. It might be business development. The person who is going to be the business person on a day-to-day basis, assisting in our actions and activities to consolidate the distribution networks. We also had somebody from finance. In our case, we had the CFO involved because it was such a significant undertaking by Volvo Construction Equipment. We wanted to make sure that he was aware of what the potential financial implications were going to be. We also had the head of the parts and service group involved because, as we'll talk about later on, there is either a legal obligation or desire to repurchase new and unused equipment, spare parts, etc., and getting that function of the parts and service people involved early on and understanding what's going to be expected of them was also terribly important. Once you've put together the right team, well, there's also the external side of things. I don't want to overlook that because that is incredibly important for the whole process. When I was at Volvo Construction Equipment, what we did was we conducted a beauty contest, as they at least used to call it. And long story short, Mike and his colleagues at Mike's prior firm were the so-called winners of the beauty contest. But as most of you know, you really are hiring the lawyer and to a much lesser degree the law firm. And Mike made an excellent presentation. I thought he had the skills, experience, the know-how of the construction equipment market and industry, and became an incredibly valuable part of our team. And as I've said, I've known and worked with Mike now for 25 years. The second aspect of the planning is to, or it helps to manage expectations of the internal stakeholders. How long is the process going to be? How expensive is the process going to be? If you get them involved earlier on, you have an ability to manage their expectations. Also, if they see the whole picture in terms of the plan, I think it makes each of the individual members more effective than they otherwise would be. And then third, but not last, would be going over the ground rules. Things like what roles are the different parties going to play, reviewing attorney-client privilege issues, agreeing upon communication styles and who's going to be doing the communicating, and emphasizing the need for confidentiality. Dealers talk a lot amongst themselves, not a surprise there, and managing confidentiality to the degree that you can is quite important. The second part that I think was incredibly important part of the planning phase is once you've got your internal and external teams together, is developing a war plan. And I use that term not to be dramatic. Maybe I've just seen Band of Brothers too many times. but developing a war plan, I think, is incredibly valuable. And it helps to think of it as a war because there'll be a number of battles against different dealers. Again, not looking to be dramatic here, but overall, you've got your plan for achieving the ultimate objective, which is the consolidation of the 3 distribution networks. The first aspect I'd say there is analyzing the field. Who carries, what dealer carries what line, what sizes of territory do they have, what performance has the dealer demonstrated over the last years? Do the dealers have an ability and willingness to grow? Some do, some don't. And then, of course, existence of state legal protections, depending upon what jurisdiction the dealers are in. Then the second would be focusing on some of the low-hanging fruit. I used the expression with Mike earlier today about just kicking the hornet's nest and having all of the hornets come at you at one time. It's not a smart way to try and manage the process. So if you can pick off some dealers, maybe some smaller dealers or some non-performing dealers, or dealers who are in states where there is no legal protection, dealer protection statute, get them off the field first so that you can save the more difficult situations for a time that is more appropriate, more suitable, more favorable for you. I think one of the topics that we'll come up with, and in retrospect was probably one of the most valuable, was delivering bad news face-to-face, in person. My colleague at Volvo Construction Equipment, who is the head of dealer development, had been in the industry for many, many years, real veteran, and he recognized and thought that he owed it to the dealers to deliver the bad news face-to-face. And I think that was a brilliant idea on his part. It gave the dealers somebody to yell at so they could vent. I think they ultimately respected it and appreciated that the bad news was delivered face-to-face. Oftentimes, it's an email or a letter from a lawyer, and he would make the effort to go to some far-flung places to deliver the bad news. And I think that produced a lot of positive consequences. It allowed him to negotiate the terms of the termination while he was right there, allowed him some additional degree of flexibility. They'll talk about in terms of repurchasing used equipment. One thing, though, that I do want to emphasize is before you start taking action to terminate a dealer, make sure that you've reached agreement on the terms and conditions of the dealer who's going to survive and take over the terminated dealer's territory. You don't want to get caught over a barrel where you've started action to terminate a dealer, but you haven't agreed on what commitments the surviving dealer is going to carry on with your line. So those were just a few things that I thought had some overlap between legal and business, but very important if you're going to increase the probability of ultimately winning the war. Mike?
Right, thank you, Mike. And Mike Going was talking about managing expectations. And one aspect of that has both business and legal implications would be the financial expectations, because the cost of litigation in the U.S. Is and has been in some ways out of control, certainly higher than most people even in this country, but someone in Europe or Japan or wherever a parent company is would anticipate. And so making sure that people have realistic expectations is important. And today, 25 years later, this is pretty much SOP. I know it is at our firm, but at the time, Mike was really groundbreaking in terms of coming up with a budgeting spreadsheet in Excel that was broken down in excruciating detail by all the ADA task codes, and there were some Anglo-Saxon expletives uttered by various people having to deal with that. But it was definitely an exercise worth undertaking, because one of the most important things for business people is certainty. And if you have some idea of what it's going to cost, it also helps you plan for it, manage for it, budget for it, etc. As far as the litigation goes, even before there was litigation, the sharks were circling, and we knew that because various dealers around the country who had no apparent connection with one another, other than the fact that they were CCing claims lawyers on their correspondence, were sending letters to set the company up for litigation. It might be, for example, a Samsung dealer that had never been a Volvo dealer trying to place an order for Volvo equipment. And not long after that, the first of the lawsuits started coming in. And actually, given the number of dealers being terminated, the number of lawsuits was not that great, but still they were not insubstantial. And ultimately, there was litigation going on in federal and state courts in Arkansas, Connecticut, Illinois, New Jersey, North Carolina, and Texas. Now, the good news is there was a favorable outcome for Volvo in every single case, including a case that Volvo itself ended up filing. But how we got to that result varied and quite a bit, and we'll talk about why that is so. The lessons learned, though, just to summarize, and we'll go through these in greater detail in a minute. One is random acts of kindness really can either help avoid litigation or minimize exposure. And certainly, as a business person or a lawyer in-house or outside, you want to pay attention to the written contract, what it says you can do. And that does hopefully reign supreme, but it doesn't always. And we'll talk about why that's the case. Most companies would like to have these disputes resolved on their home turf and believe that they would have a home court advantage. At the time, Volvo Construction North America's home turf was Asheville, North Carolina. But for various reasons that we'll talk about in terms of having all the disputes resolved there, the Mick Jagger rule applies. In other words, you can't always get what you want. And sometimes you do have to litigate or arbitrate elsewhere. But there are ways to get the equivalent of a home court advantage, even when you're playing an away game. There's the saying in litigation and life, the best defense is a strong offense. That's true up to a point, but sometimes the strong offense can be offensive, and there's some important judgment calls to make, and we'll talk about those. And last but not least, in litigation, as in international diplomacy, peace through strength often works. And so a show of force may, while it is expensive, may end up saving money in the long run. I think that definitely happened here. In terms of the random acts of kindness, Mike, you talked about that a little bit, but I don't know if you want to elaborate on what the head of dealer development did at the time, or from your perspective, what that helped accomplish as the litigation unfolded.
I think it was very, very helpful for my colleague to respect and appreciate the efforts that had been made by the distribution network. And I think he was able to put himself mentally into the shoes of the dealer. Oftentimes, these were businesses which an entrepreneurial person, say 20 years before, had started and grown the business, and now the OEM was taking this unilateral action to potentially jeopardize and damage that business. And it's helpful to think of it from the dealer's perspective rather than simply what is your company, the OEM, trying to achieve. And my colleague, the head of dealer development, as I said, took it upon himself to be the voice, the face, the physical presence of Volvo Construction Equipment. I went with him to a number of different dealerships. I remember flying to Wilkes-Barre, Pennsylvania, and terminating one of the dealers there. The dealer had, at some point in the past, been involved in manufacturing munitions. And so as we were waiting in the waiting room, I remember pretty vividly in the cases, display cases, there were various shells, military items, ordnance there, which caused us to have a a little stronger backbone and to look at one another and provide some comfort and support to one another, knowing what we were going to do. But I really do think that the dealers appreciated and respected him coming to deliver that bad news. I think the usual way that that's done, as I said earlier, is by a letter from a lawyer or a letter from the company. And I think that leaves a very bad taste in the dealer's mouth and makes them more prone to resort to litigation, find their own lawyer, and let them battle it out. And from the business perspective, litigation is usually not the most efficient way to resolve a dispute. But having said that, if you've properly analyzed your situation, you shouldn't be afraid to go to trial. And I think the dealers do watch what's happening. They may not be personally, or their company may not be involved in a particular litigation, but they know that they're going to have to deal with the OEM at some point in the future. And if you can demonstrate to those who are watching or those who are involved that you're not afraid to go to trial in appropriate situations, I think that sends a message, a positive precedent, and will help pay dividends down the road as you proceed with the project.
I would simply add, regardless of whether the dealer being visited was one where got combat pay and had to wear a Kevlar vest, the emotions and egos are important. These are a commercial divorce. There's a property settlement, but there also is emotion and ego involved. And simply showing respect helped. And it also helped with cases that nevertheless went to trial to be able to say that the company offered that. I think that went a long way in the eyes of judges and jurors. And bear in mind, there was no pot of gold at the end of the rainbow that Volvo was offering in terms of assistance. And there's no pot of gold at the end of the rainbow that anyone got from litigating either. But simply the gesture, was important. And there were things the company could do that didn't have a huge financial impact. They went a long way toward truly easing the burden of transition and making people feel better about a bad situation.
Just two quick examples. Under many of the statutes, it'll say that the OEM has to repurchase new and unused equipment, but it doesn't really define what new and unused is. And so my colleague, if an agreement was going to be reached, he would be there face to face and would be in a position to negotiate what the parties agreed to be new and unused equipment. It might be that if it has less than 250 hours on it, he might even be willing to go up to 500 hours on the equipment, that we would agree that it was new and unused and that we were going to repurchase it from him. Similarly with the parts, that's usually a higher profit margin for the dealers. And we might agree to allow them to continue to sell parts for a period of time and then allow the dealer to sell the parts back to us, whatever was remaining at the time. So my colleague was able to basically negotiate what those terms and conditions of separation were going to be, which was going to be not possible if you simply delivered a letter of termination.
Or waited for the inevitable lawsuit, or both. The starting point, of course, is the contract between parties. And fortunately, there were written contracts in place with all of these dealers, although actually many of them had expired by the time these disputes arose. And these were well-written contracts. They said they govern the entire subject matter, could only be amended in writing, no promises and understandings not reflected in writing, all the standard boilerplate. But those of you who have been through this type of litigation before know that there's a cottage industry of plaintiffs' attorneys who try and argue otherwise. And not to pick on Dady and Garner, that was only one of the plaintiffs' firms involved, but their complaints are all pretty much cookie cutter, and they talk about the written portion of the agreement. That's only the starting point. They claim that there are oral promises that were made, sometimes by people who were no longer longer with us at the time, so it's hard to cross-examine anybody about that. And basically the argument was that everyone had been promised, either orally or through course of dealing, do the job, keep the line. In other words, you would only be terminated for poor performance. And while there were some dealers that were judged to be better, no one was being terminated for having done a bad job. That wasn't the issue here. Through these cases, both defensively and offensively, we established some strong precedent that not only does the written contract govern, but it even governs after its expiration, which was important because that closed the door on the plaintiffs trying to argue that there had been other changes. And the decisions that we obtained were very clear that couldn't be modified except in writing, couldn't be modified by the implied duty of good faith and fair dealing. And the two major places where those precedents were established were one at the district court level in Chicago, affirmed on appeal by the Seventh Circuit, and in the Western District of North Carolina, where Volvo was headquartered at the time. That was affirmed by the Fourth Circuit in Richmond. And those precedents are something that manufacturers and franchisors to this day can take advantage of. But yeah, that's only part of the story, because besides common law doctrines, there are state laws that govern these relationships quite often, and they may prescribe a form or length of notice required. They may say you can't get a no-fault divorce from a dealer, or you might have to repurchase inventory or even provide compensation. And what's also an issue is that in many cases, these state laws will apply, even if the contract says it's governed by the law of some other state. And most of these laws cannot be waived by contract. And there even are some states where obtaining or attempting to obtain a waiver may itself violate state law. So how do you keep on track of that? And we don't have time to do an online demonstration of this during today's program, but Foley has a map that you can register for at map.foley.com. And if you scroll over it, it will, you can identify what states have laws that apply to all kinds of dealer and franchise arrangements, as in Wisconsin, Connecticut, Arkansas, New Jersey, among other places, and also which states, and there are many more of them, have statutes applicable to particular industries, whether that be motor vehicle equipment or even different types of equipment. And the plaintiffs in these cases tried to argue that the Volvoized equipment was within the scope of industry-specific statutes, and sometimes that got fairly entertaining. For example, in Corpus Christi, Texas, where we had a 2-week trial, the plaintiffs at the time, Texas did not have a construction equipment statute. There was an outdoor power equipment statute. That's a term of art applicable to things like lawn and garden equipment. But the plaintiff's lawyer was trying to argue that Champion motor graders were outdoor power equipment. And he would ask every witness, is the equipment used outdoors? Yes. Does it have an engine? Yes. Is it equipment? Yes. So in his world, that made it outdoor power equipment. We finally were able to shut that down because our local counsel had a partner who was in the Texas General Assembly. And it turns out that there was a definition of outdoor power equipment, not in that statute, but in the tax code. Similarly, in one of the cases in Chicago, there were 7 or 8 dealers that had filed suit from various U.S. states and Canadian provinces. And the shameless way that they tried to invoke industry-specific statutes was almost entertaining. For example, they would argue that in Montana, this construction equipment was actually farm equipment because there's a statute in another state, it was argue that a statute applied that specifically excluded farm equipment. And the district court, fortunately, in the Seventh Circuit didn't buy that. Another important principle is the major contracts at issue specified in the case of Samsung that Illinois law governed. Champion had both South Carolina and Ontario. And the dealers were trying to argue that that meant that the dealer protection laws of those jurisdictions applied across the country or north of the border. And both federal courts in Chicago and in Carolina shut that down. And that's an important precedent that stands to this day, that just because it says Illinois law, for example, the Illinois franchise law does not apply.
One important point, I think, especially to a company who's coming into the U.S. market, these laws, more often than not, I believe, arise, one, because there's usually some egregious situation that causes people to take some action, but usually it is some dealer group that is lobbying the legislature, the state legislature, for protection. And you see it, Mike, correct me if I'm wrong, but with automobile dealers, you see it with beer and liquor distributors. There's similar kinds of protections. One thing that a company, again, especially coming into the U.S. for the first time, should establish some sort of a government affairs kind of function so that they have visibility to these efforts and can try and influence whether a state adopts a law or at least perhaps what the terms of that state statute may be. Otherwise, it gets adopted by the legislature in a particular state, and it is something that you're going to have to deal with later on. There's also, if you don't want to create a government affairs organization, you can join trade associations. For example, the Association of Equipment Manufacturers, which is a great trade association for heavy equipment dealers, both ag and construction equipment. And they often have people who are monitoring attempts in the various states to pass these kinds of dealer protection statutes.
And unfortunately, monitoring and even lobbying and contacting elected officials doesn't carry the day for manufacturers, because legislators can count votes, and it's beyond the scope of today's presentation. But since you raised it, back in 2017, North Dakota adopted a farm equipment dealer statute that was the most far-reaching that I've ever seen, and basically that anyone's ever seen. And yes, the major companies fought against it, and the Association of Equipment Manufacturers fought against it, but there were many more powerful dealers in North Dakota than there were manufacturers. And in that situation, AEM and a coalition consisting of AGCO, CNH, John Deere, Kubota filed suit, and we were able to have the statute struck down on contracts clause grounds. But that's obviously a lot more expensive and risky than if you can nip it in the bud in the first place. And that also does tie into some of the arguments and points and lessons learned that we'll talk about in a little bit, which is that you need to frame the debate not just in terms of what's good for your bottom line, but what's good for consumers. And that can be a very powerful argument with a jury or a legislator. But back to the lessons learned here, I said earlier that many of these state laws say that their protections can't be waived, and yet one of the lessons learned and precedents established in this case was you can have a waiver without it saying it's a waiver. And some of the contracts at issue had the standard boilerplate that says that they're subject to the local laws of the jurisdictions where the dealer does business, but said that after you sign this, if there's some law that you claim prevents the other party, the supplier, from enforcing contractual provisions, you have to notify us, at which point then we have an opportunity to try and modify or terminate the agreement. And we actually had amazing success, especially in the Fourth Circuit, in enforcing that. And Volvo argued that most of these state laws, of course, said you can't terminate without cause, but that those laws implicated this provision. And so the dealers should have said to their supplier, we don't think you can enforce this, rather than waiting until we're in the heat of battle in litigation. And the Fourth Circuit, the appeals court based in Richmond that has appellate jurisdiction over Maryland, Virginia, West Virginia, North and South Carolina, agreed and said that because the dealers had not come forward and notified the company that they thought these statutes applied and changed the rights and obligations, it was too late. And that was an important victory. Also, there's the issue of when and under what circumstances the state dealer laws can be displaced. And most contracts do have a choice of law provision. These certainly did. The Samsung agreements, which primarily Illinois, Champion, as I said, to South Carolina and Ontario, Canada by and large. But the choice of law provision is generally enforceable if it bears a reasonable relationship to the parties and it's not void as a matter of public policy. The fact that there's a state dealer law doesn't automatically mean that the choice of law provision and that applying the chosen state's law would be against public policy. It depends upon whether there's a fundamental state policy. And in our cases, including one that went up on appeal to the Fourth Circuit, what the court said was just because there's an anti-waiver provision doesn't mean that you can't displace the law. Now, Louisiana didn't have an anti-waiver provision, so the Louisiana dealer statute was definitely overridden by the contractual choice of law provision. The Arkansas statute stood, and it did have an anti-waiver provision, but that wasn't the reason that it overrode the choice of law provision. There were some findings by the legislature, the so-called emergency clause that the court found dispositive and controlling.
Mike, can you comment upon, from your perspective, I recall that a number of times the dealer would file against us in state court. And one of the options that we would consider is whether we could remove the matter to federal court. Can you comment upon the advantages of doing that in terms of the perspective or what you could expect from a federal judge versus a state court judge?
Well, there are good judges in state and federal courts, both. But the one piece of conventional wisdom that I agree with is that as a manufacturer or supplier, you're generally better off in federal court than in state court. For one thing, federal judges have life tenure. Many state court judges are elected. It's not out of the ordinary to be hit up for campaign contributions. State court chambers in Texas and elsewhere. And so where we could, we got out of state court, and it's on an upcoming slide, but for example, there was a case with multiple dealers filed in Pulaski County Circuit Court in Arkansas. And the judge said, yeah, I see there's an Illinois choice of law provision here, but I'm not sending this case to Chicago. So, we settled with the Arkansas plaintiff, and it didn't cost very much money. Then we were able to remove to federal court and get the case transferred to Chicago, where we had both a district court judge and especially an appellate bench at the Seventh Circuit that was much more favorable. And on the other hand, sometimes you have no choice but to be in state court. We have some examples of that you'll see. And it means that it's harder to get a good result, but not impossible, not even in places that are notorious as plaintiff sandboxes. Now, I know many business people and even in-house lawyers may think, well, this is just a matter of wordsmithing. You can draft around these contracts and the like. And certainly you can up to a point. But bear in mind that what you draft may not always be enforceable. And just to recap some of the lessons learned here, you can sometimes draft around these anti-waiver provisions, even if your chosen law doesn't override the state dealer law. There can still be benefits to having the contract in general interpreted uniformly, whether it's under North Carolina law or whatever state. And generally, the chosen law is still going to govern, except any provision that is overridden by state law. Also, as I said earlier, it may actually displace the dealer's home state dealer law unless there's a fundamental policy. Then there's the issue of forum selection, where you litigate. And in some places, including places where we ended up having litigation for Volvo, such as New Jersey, forum selection clauses are unenforceable, but that doesn't mean you shouldn't try. They should be in the contract, a well-drafted contract. We'll have that. We're not going to talk about today the advantages of litigation versus arbitration. That is not an issue in our cases because none of the contracts at the time had those. Dealers, of course, often perceive they have a home court advantage. They're David versus the Goliath out of state or out of country corporation. And certainly in the beginning, at least, many of the dealers tried to have their claims resolved on their home turf. And actually, 3 out of the 4 succeeded in that. The Arkansas dealer, as I said earlier, we were able to get that out of Arkansas and out of state court. But the 3 others that were filed by dealers in Connecticut federal court, Texas state court, Nueces County court, and New Jersey all stayed in those jurisdictions, although we were at least able to get the New Jersey case out of state court and into federal court. But that doesn't mean that the dealers necessarily won. And in fact, as 3 of the 4 cases stayed in the home court, but ultimately the dealers didn't get the relief that they wanted. And the case filed in Connecticut, which was one of the first ones, and it's under a very bad statute for Volvo, is a prime example. And at first blush, that looked like a slam dunk for the dealer. The dealer was saying, well, my last year in business, Samsung excavators were 75% of my business. I have to have an injunction judge stay in business. But the federal judge, who very much wanted to be on the Second Circuit Court of Appeals, and probably would have been had the 2000 election been called differently, realized that as much as he wanted to help, that there was no way he could order Volvo to license its trademark to this Samsung dealer. And moreover, when the case went to trial, and this is why going on the offensive, but in a way that is respectful, gingerly, can pay great dividends. Because yes, this dealer, the year before the termination, most of its business was Samsung excavators. But that was because there was a fire sale on Samsung excavators. The product was being discontinued. It was a huge profit center for a year. Well, that wasn't going to sustain the business long term. And this dealer also sold products manufactured by another one of your former companies, Case. And at trial, and I think this probably clinched it, we played a video of this dealer winning the award for the Case Excavator of the Dealer of the Year in New England. And suddenly, the dealer was willing to essentially drop the case and take settlement terms that had been offered and rejected 2 years earlier. Similarly, Texas, notorious plaintiff sandbox, and the plaintiff was seeking $6 million in compensatory damages. It spent, bear in mind this was more than 20 years ago, but more than $500,000 on attorney's fees, expert fees, and other costs. And yet, after a 2-week trial, it took the jury less than 30 minutes to come back in favor of Volvo. We'll talk about why that was the case and some lessons learned from that case and others. Similarly, New Jersey got the case out of state court, had a much better federal judge who didn't really like the New Jersey statute, told me that privately, but was duty-bound to enforce it. And yet he also applied the law strictly. And as a result, he found no merit to the breach of contract claims or the common law claims, and he couldn't throw out the statutory claim altogether, but he made rulings about the damages recoverable so that Volvo's exposure went from $6.9 million down to $900,000, and then you're in a neighborhood where you can talk about settlement and resolve things in a way that doesn't break the litigation bank. So how do you do that? And also, how do you enforce the forum selection clause? Well, one way is if the case has already been filed, and certainly in the Samsung dealer agreement, we're able to get the Arkansas case transferred to Chicago. But another way is to consider going on the offensive. And you don't want to have litigation where you're not going to have it anyway. But if you are facing litigation, why not have it on your terms, turf? And that's what we did. And so we filed suit against multiple dealers in federal court in Asheville, where Volvo Construction is headquartered. And we're able to get the lead plaintiff to be Volvo Trademark Holding AB. AB is an acronym, and my high school Swedish is very rusty, so I'm not going to butcher that. But in any event,
the equivalent of Inc.
There you go. Yes, thank you. Subtitles, English subtitles. And AB Volvo Trademark Holding AB owned the Volvo trademark, licensed it to Ford, which had bought the car business, and then also to the truck and construction equipment companies that were still part of the Volvo family. And if you make the argument simply about dealer laws, you're fighting on the other side's turf. And so if you're losing an argument, you change the subject. And we changed the subject. And we asked the court to hold that Volvo didn't have to license the Volvo trademark to dealers that had never had it before, that withdrawing from the market, withdrawing these brands from the market was good cause, and that Volvo's trademark rights would be violated if the trademark could be used by Samsung champion dealers that had never been licensed before. And we actually were able to tie that into the protections of these state dealer laws, because they often define a protected franchise or dealership in terms of the trademark. And so our argument was, it doesn't matter if the products are the same under the hood. The issue is what the trademark is, and that is controlling. And eventually we won on that argument everywhere. We had a lot of procedural fencing, and it's like a Civil Procedure 101 course in terms of trying to get the cases where we wanted them. I've mentioned the fact that we transferred Pulaski County, removed it to federal court, and transferred to federal court in Chicago. After Volvo trademark filed its preemptive strike. Many of the dealers, although they had answered and asserted counterclaims, also filed a suit in Little Rock, Arkansas. They said, well, obviously you don't like Arkansas, so that's where we'll litigate, but we got that transferred to Asheville. So at the end of the day, most of the claims, certainly the ones that were decided as a matter of law, were decided in Chicago and Asheville and affirmed on appeal. In Illinois, the court held that the expired contracts continue to govern. The Illinois franchise law didn't apply. And the implied covenant of good faith could not override termination without cause provision, and all the other provisions, tort claims and the like, were barred. Seventh Circuit affirmed, with the exception of the main franchise law, which hadn't really been addressed before. And according to the appeals court, that presented a question of fact, whether Volvo had the requisite good cause for termination. That was the only claim, one out of 7 or 8, that went to trial in Chicago. And we got an erroneous jury instruction that the Seventh Circuit ultimately corrected. But at the end of the day, the precedent is and was clear that the only protected, quote, franchise, close quote, was the particular trademark contract. In that case, Samsung rather than Volvo. And so that's another drafting tip. You need to make sure that you define the product that way, because there are some contracts, and there were actually some at issue in these cases, that said any product manufactured by the company. But we all know it's not uncommon for there to be private labels, joint ventures, and the like, where different brands are made by the same company. In the case where Volvo went on the offensive, the federal court in Asheville, by and large, ruled in Volvo's favor. In fact, did. But on appeal, the Fourth Circuit, as I said earlier, did find that the Arkansas Franchise Practices Act applied. And so that issue went back down to the district court. And this is a good example where it's not over till it's over, and there are ups and downs in litigation. And we had an expletive moment when the federal judge in Asheville said, looking at the statute, well, the Arkansas statute says you have to have good cause for termination. The statute says good cause means performance deficiency. So you don't have good cause, Volvo. I'm going to grant summary judgment on the Arkansas statutory claim. And then the only issue for trial is what the damages were. And under the statute, the dealer, because it won or will have won, will get attorney's fees. But at trial, we convinced the jury there were no damages, and then argued to the judge, well, there were no damages, and you only get attorney's fees that are reasonable. What is a reasonable attorney's fee for 0 damages? The answer is 0. And
I like that math.
I do too. I mean, it's impeccable. It's logic 101, and the math is easy. You don't have to take off any shoes and socks to do it. And the district court judge agreed. The Fourth Circuit affirmed, and so that plaintiff, having gone through discovery and a jury trial and paying damage experts, had nothing to show for it. And you can bet that's a strong deterrent for other litigation. Don't have too much more time. Want to make sure we have time for questions too, and we can stay a few minutes later if people do. But even if you're not on your home court, probably especially not, you need to explain to the decision maker why what you're doing is in the best interest of local customers. Corpus Christi, we can say, look, if status quo remains, you're not going to be able to get Volvo equipment from one dealership. It's like going into McDonald's and being told, well, we don't sell Big Macs, you have to go to Burger King. And also, the David versus Goliath argument doesn't always hold. And for one thing, psychologically, having the judge and jury see the dealer that won the beauty contest can be helpful, because although it's not relevant, most of the jurors in these cases, I think, realized, hey, if it were up to me, I'd much rather have the one you chose rather than the plaintiff. And also, you don't want to go on the attack, but you can show why the plaintiff is not so sympathetic. The plaintiff has other product lines, or in Corpus Christi, that dealer, again, this was more than 20 years ago, paid himself more than $1.5 million in salary for a very small dealership in South Texas. That didn't even count paying rent for 5 dealer locations to himself, Amex bills of $35,000 per month plus for entertainment, clearly personal. He just was not a very sympathetic plaintiff. Yeah. And we didn't attack it.
But that's a shot across the bow of beware discovery.
Yes.
Because if you really get into the weeds, you find a lot of not so attractive things. And the same reverse can also be said. So you need to be very sure about what's in all of your files and what actions have your dealer representative or your, let's say, sales manager who visits this dealer, what has he or she said and done with the dealer that you're going to have to try and explain later on.
And you don't always know all the skeletons in your own closet, so you've been through the files and interviewed the appropriate people. And by the same token, going on the offensive and, for example, claiming performance deficiencies, that wasn't the grounds for termination. That's going to backfire. You need to justify it from a business standpoint in ways that consumers can relate to, regardless of their education. You're also more likely to win if you focus on things like protecting the brand, not the state dealer law issues. And there's the whole issue of peace through strength. And yes, there was a lot of litigation, but given the hundreds of dealers that were terminated, we really didn't have that many lawsuits, and even fewer that went all the way to trial. You could count the ones that even got close to trial on one hand. So not being afraid to litigate, going on the offensive, and entering into reasonable settlements really does deter a lot of these plaintiffs' lawyers, because they're going for the low-hanging fruit. They're like the burglar whose house has the floodlights and an actual security system in addition to just a sign. They go down the street. And that's certainly what happened here. So I know we have the capability through the chat feature to pose questions for people in the audience to pose questions. And also, here's our contact information if you want it. But if there are questions, Mike and I can try to field them now.
Although we are at the top of the hour, so I would suggest if there are questions, you see the contact information, please let us know. We'll be very happy to get back in touch with you, clarify, or address whatever your questions are. Otherwise, thank you very much for attending today. I appreciate your attention and your time. And Mike, I appreciate the opportunity to come and talk.
Well, thank you. And as I said at the outset, we'll have others in this webinar series coming up starting May 14th, where we talk about the supply chain, and then a whole day focused to distribution and franchise law from September or October. The exact dates are not set yet. So hope you'll join us again. Thank you.